All right, well, welcome those of you who are joining us live. We are here and ready to get started on today's topic. Can a tenant terminate the lease if there are repair issues at move-in? And, this is something that comes up from time to time because, sometimes, tenants have unrealistic expectations, or the landlord has made promises and hasn't come through. And so a tenant is, going to be pretty upset, when this happens. And one of the things they're going to do is either threaten to or actually, decide they don't want to be here anymore. And so if that's happened to you or it's happening to you now, it's possible. If that's happened to you in the past or it's happening to you now, what could you have done differently, setting up for that moment? What should you do if you find yourself in this situation where a tenant just says, look, I want out. Hey, James, good to see you as always. I want out because you promised this, or it should be this way, and it's not. And so because it's not, I want out, and there's nothing you can do to stop me. What do you do? And so I want to give you some advice on what I would recommend that you should do in a situation like this. And so I've also got, along with today's lesson, I've also got some prefab questions that I got. If you ask one of these questions and you're here waiting for an answer, I've got it, I'm prepped, I'm ready to go. But for those of you who are out there who would like to submit a question, we welcome you to do so through the live stream. There's a chat function here. Go ahead and add your question to the chat. If you, however, would like to jump ahead and get a question that I get to review ahead of schedule and prepare an answer for, we welcome that. You can either do that by being a member of our Facebook group, Texas Landlords, or by sending us an email ahead of time. For those who are part of our newsletter, every week they're going to get an announcement, and sometimes people submit questions through email from just a response to our newsletter. So either way, you can get a question in ahead of time, or you can submit a question here live on the chat, and I'll answer all of those questions during this live. So again, back on the topic, today's topic: can a tenant terminate their lease if there are repair issues at the move-in? So we're going to talk about 5 different things that you need to consider in these situations if it happens to you. And by being prepared for this, you kind of set yourself up for success in the future to avoid this kind of situation and know exactly what to do or what you should have done, when it happened to you. So right from the start, what do you do? Can they terminate? Well, you got to ask yourself, has the lease even been signed? Has any money been paid? Because if no one's yet on the hook, of course the tenant can pull out and say, you know what, forget it. I'm not into this. I'm not going to do it until the lease has been signed and or until some amount of money has been paid and accepted. There really aren't any obligations in place yet. The fact that you've been talking about terms, the fact that you've been discussing, what could be your lease agreement isn't enough to establish a lease. You're going to need some agreement and some offer and acceptance. Certainly if you've accepted an early deposit or you've accepted first month's rent or both, even if you don't have a signed lease, they can say you are obligated to act. Just the same, you can say they're obligated to stay and perform on this contract. And so, but if nothing's been signed and no money has been paid, it's unlikely that either of you is bound to the other. And so, yes, a tenant in that situation can very likely show up on the day of move-in if nothing's been paid, nothing's been signed, and say, sorry, I'm leaving. I'm not buying this, or I'm not renting this property from you as it is. And so by understanding the ramifications of what it means to accept rent before you have a signed agreement, or what it means to finally sign that lease, you know that at that point, they're probably locked in. But that's not the only thing you have to consider. There are other considerations in these situations. Another is, what's in the lease? If they have signed it, do you have an as-is provision? Many good leases do. And the as-is provision essentially establishes that the tenant accepts the home in its present condition as it is, and hasn't made any kinds of requests. Many leases have blank lines underneath that provision where a tenant could make certain requests for repairs. Now, something that happens a lot lately is that tenants will take property sight unseen. They'll do it online. They saw a few pictures, and maybe those pictures were old. And so the question would be, if they took it as is, subject to some misrepresentation, are they taking it as it is because the version of it was not probably presented? You might have an issue there. But if everything happened the way it normally happens, where a tenant had an opportunity, whether they elected to take this opportunity or not is different. But if they had the opportunity to come in and view the property and they accepted it in its condition, once they signed that provision with an as-is provision asking for nothing else, they're locked in. They're obligated for the entire term. And whether that's a month to month or a year and a half or longer, they're locked into that agreement based on the as-is provision and their reasonable term accepting the property in its present condition. So Jeff C. writes, what is considered sufficient heat and cold from HVAC? The unit was there when they moved in, but wife complains living room that has floor and ceiling windows is cold. Pros: maintain the HVAC 2 times per year. Okay. Well, I'm going to get to something similar to this later in the talk, but let's assume that the unit is otherwise working, because that's what it says. It says it's working, but maybe it's not working to the satisfaction of the tenant. And so it's a little cold. I don't like it. Maybe the windows are drafty or something happened. Again, you've got this as is provision, and it's really going to come down to whether or not this rises to a certain level. In fact, I may as well just jump onto that point. It's actually my 4th point, but I'll jump to it. Is the repair issue cosmetic, or does it, quote, materially affect the health and safety of an ordinary tenant? And so HVAC issues or heating issues come up a lot with this consideration. So let's think about it. The air conditioning isn't cooling down the house sufficiently in the months of July or August in Texas. That's probably going to be a problem. And so what does the court view as insufficient? Well, kind of a rule of thumb, it's not stated law, it's not black and white law, but a rule of thumb is if the house cannot be maintained at a temperature at least 20 degrees cooler than it is outside on a hot day, or 20 degrees warmer on the inside than it is outside on a cold day, you probably have a problem. So let's say it's 90 degrees outside, and the house, they want the house to be at 70. And the AC gets the house to 80. Well, that's not more than 20 degrees difference, or that's within that window of just how warm it is outside, but it's not doing a fair job. So the question would be, maybe the unit's not functioning properly, but is this person's health or safety in danger at 80 degrees? Maybe not. And so probably not. I mean, nobody's likely to get a heat stroke at 80 degrees. But let's change the facts. Let's say it's 110 outside and the lowest your AC can get the house is down to 100. Same 10-degree difference. That's probably going to be a problem. And so because your unit can't handle that heat, and it's keeping people inside the house at 100 degrees, you probably are materially affecting the health of any ordinary tenant who is in that house. So these considerations have to be taken seriously. Same situation, it's 110, and the house doesn't get cooler than 80 degrees. Well, again, it's 80, it's 110 outside, and your unit is bringing down the temperature on the inside of the house 30 full degrees to a level, maybe it's not super comfortable, but people's health are not materially at risk. Now, what you're discussing in this situation isn't a health risk, but it may be a customer service issue. So no, it probably doesn't rise to the level of a material effect on their health. But man, nobody's going to be happy with that. And so it's unlikely they're going to renew. And if the problem comes up where you knew that the unit maybe wasn't sufficient for the square footage of your house, or you were aware that there simply wasn't enough insulation in the home in order to get this, and you've heard complaints, for example, of high electricity bills from prior tenants, that's bad evidence against you of the suitability of the home. It's not necessarily a violation that materially affects the health or safety of an ordinary tenant, but it could be a breach of your agreement with your tenants that could ultimately affect you if they decide to sue you for maybe diminished value or just straight up breach. And so I would concern myself if there are significant lapses in the HVAC that create problems, even if they don't arise to the level. But certainly if they meet that threshold where they're likely affecting the health or safety of an ordinary tenant, you must act, right? If it's getting close, you probably should act. Maybe that unit's too old, or it just can't handle it, or just needs some maintenance. So address the issue certainly, but recognize when something is again, a cosmetic request is very different from one where there's a material effect on someone's health or safety. I hope that helps. I know it was quite long, but I hope that helps. So we have Law and Order Body Cam Chronicles. That's interesting. My landlord just self-help eviction after I reopened home to our city health department. Local police won't get involved, and now I'm being sued for damage. This is wild, but I have so much proof. Not mad. Okay. So let's see, you reported home to the city health department and the local police won't get involved. Well, I mean, again, this is very similar to the last point that I just made, is the government isn't going to get involved, generally speaking, for a purely cosmetic repair or for a defect on the premises that doesn't materially affect the health or safety of an individual, particularly in Texas, an ordinary tenant. So it has to meet certain thresholds. There has to be something really bad with the unit for it to rise to a problem where judicial intervention is needed or some kind of government intervention. Certainly a city can come in and red tag a property that's just in a bad position. At that point, if it's uninhabitable, the different rules and regulations kick in. But assuming it just doesn't rise to that level, yeah, the government's not typically going to act. If, however, you do have evidence that there is a defect that materially affects your health or safety, I would definitely present that to a court. Eviction Pros writes, hey, Ernie, happy to be here. Glad to have you here. We love pros of all kinds, but in particular, Eviction Pros. Dylan Thrasher, can't wait to hear the answer to my question. I was the e-filing pro tip question. Keep getting rejected by Dallas One for not using their form. I got your answer. I've got it queued up, and I will get that to you, Dylan. So let's go ahead and move on to what was my third point. But something else you need to consider if your tenant wants to terminate right at the point of move-in. Was the repair issue requested prior to signing the lease? And we talked about this in certain leases where the as-is provision is contained. There might be a couple lines underneath where the parties say, I take it as is subject to the landlord repairing the windows in the front, or that back door that was a little loose. If you agree to do it and it's in the lease or the request was made prior, particularly if that request was made in written format, and an email might suffice in this situation, an email saying, hey, would you take care of X, Y, or Z prior to move-in? And you said, yep, no problem, don't worry about it. And they show up and it's not done. Could that serve as some modification of your lease that constitutes breach because you agreed to do it prior to move-in? Maybe. It's an argument, and it's one where I would say, look, if you open the door to this kind of situation, you're going to have some kind of consequence to it, and it could be termination of the lease. It could be, a lawsuit for breach of the lease. And if you've damaged the tenant in some way or failed to make a necessary repair, you might find yourself in a tight situation that you don't want to be in. So, again, was there some kind of request, particularly a request made in writing prior to the lease? That could exacerbate the situation and create an issue where you're having to conduct a repair or allow someone to leave. And so the last thing that I always tell landlords to consider, if a tenant is threatening to leave because of some nonconformity with the lease or some repair that was requested or some other issue that they're suddenly bringing to your attention, you got to ask yourself, are you better off letting this one go? Are you better off just saying, you know what, it's fine, I'll take the keys back, you can walk away, here's your deposit and here's your first month. Sometimes it's worth handing money back to somebody that is just going to be a terrible tenant. Let me give you an example. Let's say you've got a unit and the rent is $1,000 and the deposit is $1,000, and they come in hooting and hollering and making all sorts of accusations, and it's very likely that they're going to sue you immediately because they're not going to live in your house. They've already walked out. They're not coming back. Well, if that's the case and they decide to sue you, a lawsuit's likely going to run you way past $2,000 if you're having to defend yourself. And I can't tell you right now because I don't know any of those facts. This is a hypothetical. But $2,000 goes quickly in a lawsuit. And for what? I mean, if you can completely avoid it, give them back the money, give them back, cut ties with somebody who you can already see was going to be terrible. You might end up saving yourself time, money, and stress just by letting this one walk. Now, in other situations, it's a matter of, no, you're obligated to the lease, you got to stay. We can work things out if it's a valid repair request. But as far as you being able to just unilaterally terminate, no, I'm not going to accept that, but I will conduct this repair. If you can do that and they're reasonable, then yeah, by all means, keep them, get the repair done, and keep the tenant. But again, you can't reason with an unreasonable person, and you probably don't want to have to deal for 12 months with someone who's just going to yell and scream every time. You don't always see this. This is not something that comes out sometimes very easily during screening, unless you're talking to prior landlords, which you should always do. And so if it turns out that you just got a maniac, you may just want to part ways and just say, you know what, it's okay. Here's your deposit and your first month. You can go ahead and go. I'll take those keys back. That might end up saving you a whole lot of time and effort. that puts you in a better position going forward. All right, so Law and Order, Body Cam Chronicles writes, thank you, Ernie, for dedicated so much time to educate the public. You could be doing other things, but you're here with us. And for that, I am in, and I'm sure those who will see this stream, we thank you. Well, you're welcome. Yeah, I mean, this is what I do. I hope that this is helpful. Whether you're a landlord or a tenant, there's a lot of, good information here that people can use to make sure that you're on the right side of the law at all times. And I appreciate that. Eviction Pros writes, he really is the best. There is so much information that he has shared that it is almost impossible to find elsewhere. You are much appreciated. Hey, you know what? Again, those kind words do not go unnoticed. I appreciate you guys coming and posting and sharing, and yeah, we enjoy helping our clients or even non-clients who just come and want to learn a little bit more about the law. I've been doing this for years, and I don't see myself stopping anytime soon. So I appreciate you guys watching. All right, so let's see. So let's get to our first question. So we've got a set of questions here that I'm going to get through for the rest of the time that we're here on this live. And the first question comes from a woman named Rosie. So Rosie writes, let's get this to the stage. When is cash for keys recommended, and what is the correct way to do it? So for those of you who are not familiar with this option, the cash for keys option is one that I talk about in other videos and that I have mentioned extensively in live events and with clients. It's an option that you can give to tenants when you're looking to part ways, and maybe you want to move back in, or maybe you've got another tenant who's interested in coming in sooner than you anticipated, or maybe you've got a tenant who's in breach and you just foresee a long drawn out battle that is just going to cost you more money than it's worth. At that point, you may want to consider offering cash for their keys. Now, I want to make sure it's clear what it is I'm describing here, because there are no hard and fast rules like after day 7 you ought to do this, and after day 14 you ought to do that. I'm not saying that at all, but generally speaking, it's best if you make this offer early in the process as opposed to late. At a certain point, it's just going to be an exercise in frustration, because it doesn't make sense to lose money from rent you were unable to collect and then pay money to the tenant just to get them moving. My suggestion is always start with the eviction, and if you're able to speed up the eviction process with cash for keys, then that might help. But I wouldn't offer cash for keys, wait 30, 45, 60 days for that not to work, and then begin the eviction process, and then continue to offer cash for keys. That's a bad recipe. So my philosophy is always evict faster if you've got a valid claim for eviction. But if cash for keys can get you possession faster than the eviction can, then it might make sense for you. So let me paint a picture for you. You're at the beginning of the month. You haven't received rent by day 7, and so you've issued a notice to vacate. And sure enough, you gave a 3-day notice, and they have not moved out. So here you are, say about day 11 or 12 of the month after you've given notice, and you say, well, I've waited the requisite amount of time, now I'm going to file. And so here you are in the early third or near half of the month, and you file that eviction. They get notice, say 10 days later, and you're headed to trial by the end of the month. And they say, look, I can be out by the end of the month, but I need some cash to go. You may decide, look, if I can get you out by the end of the month, I actually save more money than if I wait for the court, which is going to give you an opportunity to file an appeal and could extend the process 30 to 60 additional days. But you're always going to want to have this cash for keys offer in some kind of written agreement that says, in exchange for X, whatever the amount of money is, and it should be a reasonable amount. Don't go crazy. But in exchange for X, you agree, number one, to hand me the keys with an empty unit. You get no cash if you left your stuff behind and I got to deal with it. So first and foremost, I'm getting keys by the date agreed and an empty unit. You'll get cash, but you agree to waive your deposit. I'm not going to have to, I don't owe you the deposit, and I will dismiss this case against you. If you do things soon enough and you're holding 1 month of a deposit, you're not applying it toward rent. They're waiving it in exchange for leaving the house in good condition, bare, and keys in your hand before the end of that month. Guess what? You've lost, virtually speaking, no money. Right? Sure, you had a filing fee for the lawsuit, and sure, you're not going to get what you expected in the next month's rent, but you're going to get the property faster, so you've mitigated your damages and lessened your losses. So if you're doing this early, again, my recommendation is proceed to eviction first, so you light a little fire under them, but make sure that you're doing this in a short period of time, preferably before you have to go to that eviction trial. And if you have keys and an empty unit, and the property's in decent condition, go ahead and work through this deal, take the money, hand it to them in exchange for keys and an empty unit, and then dismiss the case. But don't do it without something in writing signed by them, and consider that deposit. Remember, you want them to waive any interest in the deposit in exchange for a dismissal of the lawsuit and termination of the lease. Right? By resolving things early, you get your property back, minimal losses, and you kind of prevent them from going a little nutty and maybe dragging things out or damaging the property. It's not a bad option. And so if you're still in a position where you can make this offer, that's the way I would do it. Eviction first, and do it quickly. Don't wait till months and months have passed. It has far less value outside of the first 30 days. So I hope that's helpful. Next. Okay, so this is a little bit longer. Law and Order Body Cam Chronicle says, excellent question, Rosie. Yeah, I thought it was a good question. It's something that happens a lot, and it's something that landlords should consider. But consider it with these caveats. Okay, I have a Section 8 tenant who owes $282.88 for running water, and there was damage to the unit, a broken door. I'm not sure how to go about collecting payment. Any suggestions? Solita Cisneros. Well, Ms. Cisneros, and I know your question was longer than that. You had a few additional details, including that this particular Section 8 tenant has rent 100% paid. So rent is not an issue here. This is not an evictable offense for non-payment of rent, but it could be evictable based on breach of the lease, both for the damage to the property as well as for failure to pay a utility. What I don't know about your lease, Ms. Cisneros, is whether or not the utility, the water utility, is part of your lease, and whether payment of this utility has been incorporated, and whether non-payment is a default for which the tenant can lose possession. All of those details are extremely important. And if this is not the case, then it's harder for me to be able to say you've got a slam dunk path to an eviction. Now, with regard to the damage to the property, that one's a little clear cut because, generally speaking, most leases do have provisions in them that talk about damage to the property as a default that would lead to eviction. But while it should be that way, and while most cases are that way, I don't know what your lease says. But if your lease does mention the payment of water as part of the lease obligation, and they fail to do it, and it does mention the issue of the broken door or damage to the property in general, what I would recommend is the following. Yes, these are offenses for which you can either recover possession or recover payment. But you got to send notice. And so I would send notice of default for each of these defaults. And I would say, you've got X amount of days, 3, 5, 7, whatever makes sense to you. You've got X amount of days to pay for the unpaid utility and or to pay for the broken door. I will come in and repair the door, but you're going to owe me X, which is my fee to pay the handyman or the repair person, or myself having to buy a new door and having to install it myself. Whatever the remedy is, make sure they know they've got 3, 5, or 7 days to take care of it. Now remember, I would never have a tenant do the repair themselves. You go in and do the repair and you bill them for it. But if they fail to do it, issue another notice of default and then issue another notice of default. I usually go with a 3 strikes and they're out philosophy, because if you can demonstrate to the court, particularly when you're receiving all of the rent, you can demonstrate to the court that the tenant has failed to adhere to the lease. And again, I don't know what your lease says, but I'm presuming that it mentions the payment of utilities and it mentions the damage to property, both as defaults. And you've given them an opportunity to cure, and another one, then you're probably on a good path. After 3 strikes, send that notice to vacate. Last point, because this is Section 8, make sure you're also notifying whatever contact person you have through the housing authority. If your Section 8 housing has a liaison, somebody that you've been in communication with, make sure that each of these notices also gets to them, because you want them to put a little heat on the tenant and you want them to be aware that their failure to cure this defect, this default, this problem that they've caused could subject them to eviction and subject them to losing their voucher. If you never give notice to the housing authority, you could have problems, because it's very likely, I'm not reading your documents, but it's very likely there's a provision in your housing agreement that says anything that affects the tenant and that could affect their possession of the property, you have to send notice to us. Make sure you're following through and sending that notice, and you should be okay. Next question. Here's Matthew McCoy. I have a tenant that moved out 2 months ago in the middle of their lease. How would I go about getting that rent and termination fee from them if they are not willing to work with me? Well, you've got a couple of options. Sometimes people just get up and go in the middle of the lease, and there's nothing you can do to stop them. You cannot physically restrain them. If they're going to go, they're going to go. But how would you go about suing them and getting the amount of money that's presently owed to you? So you're asking it in a couple of different ways, and I want to address them both, because I don't know how much time is left on your lease. Let's just, for argument's sake, presume 4 months. And so you've got 4 months of unpaid rent left on your lease. You have the option to accelerate all 4 months. And so let's say your rent was $2,000 a month. For 4 additional months, they owe you $8,000. Well, you've got a security deposit. Maybe that's going to knock out one of the months. So now you're down to $6,000. But you also have this early termination fee. And I want to mention, I don't like putting an early termination fee in my leases because they're not usually 100%, and sometimes they overshoot, sometimes they undershoot, and they don't end up accomplishing what we want them to accomplish. But you can't double dip. You can't ask for an early termination fee and full acceleration of the rent. It's one or the other, and so I like going with full acceleration of the rent. Additionally, you're required to mitigate your damages. So you got to go and you got to, in a good faith effort, look for a new tenant. And once you find them, that cuts off the rent obligation. So let's say they owe 4 months of rent, but after 1.5 months, you found a new tenant. Well, guess what? You've got 1.5 months of unpaid accelerated rent. And if you were holding a 1 month deposit, you're down to half of a month of remaining damages. Now, there could be other things like late charges and damages to the property and other things, but if it's just rent, you've got a $1,000 claim. And so you got to ask yourself, is it worth it going after this person for $1,000 or whatever the facts happen to be in this case? Once you properly apply the security deposit, ask yourself, what's left and does it make sense for me to go after now that I've found a new tenant? If you find a new tenant super fast, say 2 weeks after this tenant vacates, you've got a new tenant. Well, guess what? You might actually owe that outgoing tenant a refund from their deposit if their deposit covered all the unpaid rent up to the point of mitigation. Now, a lot of times there are other fees involved, like a reletting cost. Maybe you paid a realtor to list the property, and that's how you got your tenant so quickly. And so those costs do kind of balloon up. But all these things have to be considered. And so let's presume, for argument's sake, that there was a reletting fee and that there was no security deposit. So all 8 months are owed, but you did find a new tenant after 3 months. Well, now you've got about a $6,000 claim. You can sue that tenant as long as two things apply. And I tell every landlord this every time they come with a scenario similar to this. You can go after your prior tenant who's breached the lease and owes you money, whether it's for non-payment of rent or whether it's for damage to the property. But ask yourself these two questions every single time. Number one, can I find them? Do I know where they live or work? Because if you can't find them, you can't sue them. And if you can't sue them, I mean, you don't get anywhere with your claims. So can you find them? Do you know where they live or where they work so that a constable can, or private process server, can go and personally, right in their hands, deliver that lawsuit? Second question for you. If you can find them, do they have the capacity to pay? Because if these people do not have any money, you're going to get another judgment, or you're going to get a judgment if you haven't evicted them. You're going to get a judgment that looks really nice on paper. And the black and white's going to say they owe you $1 gajillion, but it's virtually worthless because you won't be able to collect it against somebody who has zero capacity to pay. They don't have property. They don't have multiple vehicles. They don't have an account that you're aware of. And if they do have an account, they don't have enough money in there to cover the judgment. And so without a capacity to pay, again, you might win another judgment, or you might win a judgment in the first place, but you can't collect it. You always want to go through and get an eviction judgment, mostly because you want to get possession as quickly as possible. And sometimes you're required to get a judgment before you can get possession. But in this case, now that the tenant has left, getting a judgment isn't valuable if you cannot get access to the funds. So can you find them? Can they pay? Do they have the capacity to pay? And I'll tell you this, in Texas, debtors are protected. You can't touch their homestead. Each debtor, let's say you got a couple who signed the lease, each of them gets a car in their own name. And each debtor gets protection of up to $50,000 for an individual, $100,000 for a married couple of their personal property. So you got to pass certain thresholds to be able to collect this debt. And if you can't, then you can't access the funds, and it doesn't make it worth the chase. Sometimes we just got to let them go and we learn our lessons, or we just chalk it up to, well, that's the cost of doing business. And it's unfortunate that it happens, but sometimes it's just not worth the trouble. Also, sometimes our damages are not what we think they are, especially when we find replacement tenants quickly enough and there was a pretty healthy deposit. You may find that your damage calculation is actually much lower than you first suspected. And so that's a good thing. You move on with a new tenant and just kind of forget about that tenant and because it's not worth it to go after such a small amount in that particular claim. So I hope that's helpful in terms of how to think about these situations if they happen to you. So here is Dylan's question. Dylan was asking about this. Now, before I get to this, I'm gonna answer some of these posts. So James says, I have a tenant who claims they smell gas coming from a water heater. The water heater is new, and I have had 2 different licensed plumbers check it out, and both have said everything is fine. The tenant is still complaining about smelling gas. What do I do at this point? So here's the thing. The law requires you in this situation to address a defect on the property that materially affects the health or safety of an ordinary tenant. James, you have done the absolute correct thing. But guess what? The evidence shows there is no defect. So they can't rely on the law in this situation. If they're withholding rent, Get rid of them. They have no basis. And in 99.9% of the situations, a tenant cannot simply withhold rent because they believe there's a defect on the property. So if they're trying this, they got to go. Send them a notice to vacate for non-payment of rent. So definitely don't tolerate non-payment. But secondly, if they're threatening to sue you, I mean, okay. I mean, people threaten to sue all the time, and either if they're just bluffing or they do sue and there's no case, and the court will dismiss that case. So hopefully they're not so crazy that they're going to do this. But I've seen situations like this where the tenant has said, look, I believe there's a danger here, and I've represented landlords that have done the exact same thing and gone out and checked, and there are no problems. And so the thing that we mentioned to the tenants was, look, if you leave, you're going to owe X amount in damages. And so we can work out an early termination, but if you just breach, we're going to come after you for those damages. Or you can accept this early termination fee as our estimation of what it's going to cost my client to find a new tenant. Sometimes that works, sometimes it doesn't, but they simply cannot just withhold rent. I hope that's not what's happening in your case, because there's no legal basis to do it. You've done the right thing to have a technician come in here and confirm that there is no defect that affects their health or their safety. Okay. Okay, so Doxology says, James, have the gas company go check it out. They will surely the problem if there is no gas leak. Cure the problem. Well, they'll identify the problem if there is, and then of course if there's no gas leak, then the gas company definitely will not say. But it kind of sounds like you've already had somebody, a trained professional, go in and check it out. If, as a final precaution, you want to have the gas company come out, that they won't charge you for that. But yeah, if there is a leak, and they say, and they'll tell you, just like the water company will tell you, look, the leak exists, but it's on your side of the line. You got to pay to correct it. If the gas company finds that there is a leak on their side, well, they have to fix it. But if they detect a leak on your side, then definitely hire somebody. But it might be worth it to hire a gas company to come out. Sounds like you've already done the reasonable step. This is not an unreasonable thing, and it might end up working. I'm going to get to the rest of these posts, but let me get to Dylan's question. Can you share any tips, tricks, or best practices to help make sure that your e-filings get accepted? Dallas County JP1 is refusing to accept any forms outside of their local form they provide on their website. But it's my understanding that anybody can submit a form as long as it has the required information, and it should be accepted. You'd think so. But no, that's not actually the rule. Many courts have their own local rules. And so while generally speaking, the Texas Rules of Civil Procedure have what a petition should contain, the court is not outside of its bounds to say, we'll accept that in this format, particularly if it's from a pro se litigant. I'll tell you that for all of our petitions, we submit them with our own pleadings. And generally speaking, we've had no problems, including in Dallas County. But this court might only reserve that for attorneys. And I'll tell you that even some attorneys could be turned away if their pleadings don't conform to their expectations. Again, I've never had that experience with any court, but it could be that what they're saying is, look, if you are pro se, that is, you have no attorney who's preparing this, we want you to follow this format because in our experience, it's much easier for us to to see what it is you're asking for if you just answer these simple questions. No, you're not going to have any luck outside of getting a law degree and having a law practice, convincing the court that your way is better than their way. They've probably got these rules that they apply to every pro se litigant, and the Supreme Court is going to uphold that. A local court can have local rules and local limitations on what they will accept, particularly for a pro se litigant. And it's not worth the fight. There's nobody you can complain up to. Unfortunately, judges, just like judges that rule in a particular way that you know is completely wrong, it's not worth the fight. You're not going to convince them. You can maybe, if they're violating the law, complain to the state bar, but short of them violating the law, I don't think this form question is that. So, unfortunately, you just have to deal with that court and its limitations. So let's get back to your chat. Eviction Pro says, say we know which bank they use. All application information is available and funds have a judgment secured. Writs of garnishment are possible, but how do we know if they have the money in the bank? That's a great question, because and if I'm not mistaken, I don't think that knowing the bank is enough. I think you need to know their account number in order to get what's called a writ of attachment. So you can attach your judgment to their account number through their bank. You can't just arbitrarily say, they might have an account with Bank of America, so I'm just going to attach this judgment to Bank of America and make Bank of America find this tenant's account. That's not the way it works. If you know the account number, you can issue a writ of attachment to that account number, and Bank of America, in this case, would have to respond, freeze that account, and make those funds available to you. But sometimes, even knowing this isn't enough to satisfy the judgment if the amount inside the account is just lacking, right? And this does happen. I've seen it happen before, where an account is seized. There's a $10,000 judgment. There's only a couple $100 in the account. Most of that goes in fees anyway, and the debtor pays those fees, but there's no other money there. There's nothing for the creditor to get access to. So yes, it's possible. If you know someone of means has an account and it's a substantial account and is likely to pay, then yeah, by all means, you can file for a writ of attachment through the court. And if you have a judgment, that judgment can be attached to that account, but you've got to know that account number and the institution in order to effect a proper writ of attachment. So let's see. Tiger Harris writes, landlords must understand that the court is not a collection agency. A judgment is not a guarantee of payment if tenant does not cooperate. True. But if they do own non-exempt property, you don't really need, you don't need much. You'll need an abstract of the judgment and you'll need a writ of execution. And if they own property, non-exempt property, right? You can't get their homestead. But if they happen to own a piece of property with their brother, say, for example, they just inherited some property and you know about it, well, that non-exempt property is subject to seizure and you could get a writ of execution and essentially have a constable sale of that property. Now, you only get the share owned by the tenant, and so you may now be a co-owner with their brother, but that's better than nothing. And so that's a possibility. Certainly if they own it outright in their own name, that's even better, because you can get the either title to the property at a constable sale or the money from your judgment from that constable sale. Doxology goes on to write, thank you for answering the question, Ernie. My dad's name was Ernie. It's rare to hear it. Oh, well, I hear it every single day. James says, thanks. You are welcome. You both are welcome. Doxology writes, Ernie, I have a tenant who is not sending pictures of the AC filter change this month as we agreed to, and I'm trying to get a shower handle fixed that his wife broke. He's not responding. Well, that sounds like, and hopefully you're close enough where you can just go pay a visit, but I might send a notice to them saying, hey, as part of your contract, you're required to send X, Y, or Z. Please send it. Or just go straight to the default. As part of your lease, you were required to do X, Y, or Z. Because you haven't, you are in default. You have 3, 5, or 7 days to do it. Otherwise, continuous default could result in an eviction. Please comply with your lease and do X, Y, or Z, whatever that happens to be. In this case, you're looking for a photograph, and by giving this hard deadline, you're likelier to get a better response. So, okay, we have that. Thanks for answering. Very helpful. You're very welcome. All right, so now we have a question from Alexander Valentin. Here we go. Question number 5. What should I expect at my first eviction hearing? I manage property for an out-of-state owner. Tenant hasn't paid rent for several months. What should they expect? And can you walk me through the typical steps? Okay, a couple of things. Alexander, you mentioned that this particular owner is represented by counsel. So I'm not offering legal counsel to that owner, and I'm not offering legal counsel for what to do in this particular case. Instead, I'm offering general education tips for anybody who's going to an eviction. I have a video. It's actually exactly my most popular video. It's got over 100,000 views because it's so simple. I talk about the 4 things that you need to prove in order to win your eviction case. If you haven't seen that video, again, it's my most viewed video. 4 things that you need in order to win your eviction. And so it comes down to 4 simple things that every landlord needs to prove in order to recover possession. And so you may be asked about, these 4 things at trial, and it's as simple as the following. Number 1, was there an agreement between the landlord and the tenant? And so that's usually pretty easy, especially if you have a written lease. Was there an agreement? Yes, Your Honor. It's this written document here titled lease. And so checkbox 1, was there an agreement? Second thing, was there a breach of that agreement? In this case, Alexander says, yeah, it was a big breach. The guy didn't pay rent for multiple months. Now, that might not be the case in yours. You may have, some kind of, we talked earlier about, damage to the property or failure to pay utilities, or maybe there's an unauthorized pet or unauthorized individuals now living on the property that all constitute breach. And so number 1 was, what was the agreement? Was there an agreement? And so that's easy to prove up with the lease. Number 2, was there a breach? What was breached? What was violated in that agreement? And so if it was non-payment of rent, you say rent remains unpaid since, September 1st of this year. So September, October, and now November remain unpaid. And that is the breach that constitutes the right of the landlord to recover a judgment for unpaid rent and possession. Number 3, did you send notice? And so the court is going to require that you send notice in conformity with the rules. And so in Texas, your notice always has to be in writing, and it has to be sent in a very specific way. Those rules, by the way, are changing come January 1st of 2026. It actually gets much simpler, and your written demand for possession no longer has to be exclusively on paper. It can actually be digital if the lease allows it, and if you have followed the other rules of the court. You can actually send notice to vacate by email starting January 1st of 2026. That's not currently the law. Email is absolutely not allowed. Even if it's in the lease that way, it's not allowed by rule in Texas yet. I made a whole video on this. I will continue to make content on this very subject because the law has changed and you landlords need to know about it. But the third thing you need to prove in any eviction is, did notice get sent and how was it delivered? Did you send notice in writing and did you deliver it in accordance with the law? So the first thing again, what's the agreement? Second is, what's the breach? Third is, did you send proper notice? And then finally, what are you asking for? What were your damages? What was the total amount of unpaid rent you were asking for? Are you asking for late fees? You can't get late fees. They're not allowed in a Texas eviction. Maybe they're allowed in other courts in other states, but they're not allowed in Texas. Are you asking for other things like unpaid utilities? Can't get that in Texas. What about the deposit? Well, they only paid half the deposit. I want them to pay the rest. Can't ask for that. In Texas, you are limited to non-payment of rent, court costs, and reasonable and necessary attorney fees if your lease awards them, or if you sent a proper notice about them, if you don't otherwise have a path in a written agreement to reasonable and necessary attorney fees. So that's it. Unpaid rent, court costs, and attorney fees. It's the only money you can get, but make sure you know it. And the most important thing in an eviction is the final thing. The thing I want the most is possession. And so make sure you ask for possession, and always, always, always ask for rent if you can, right? Because the last thing you want to do is give your tenants a free path to eviction. By not asking for rent when you could have, they could appeal for free, but not forever. Starting January 2026, there should be no more free evictions. A court in every eviction is required to calculate what should be paid as rent if the tenant decides to file an appeal. It's a great new provision in the law. I'm very excited about it because I think it's going to make eviction appeals even less frequent, but when they do happen, it's going to make them fair, especially in those situations where either the landlord mistakenly left rent out, which is never a good idea, or where rent isn't involved because there's a non-rent lease violation, but ultimately they stop paying rent and you're kind of just stuck in limbo because you didn't have a cause of action for non-payment of rent until you sued them for eviction. And now you're not getting rent, but you can't add it to your petition because it's already moving forward. And so the courts have made this more fair. Again, if you want even more updates as to how the laws have changed and what's happening January 1st, 2026, I suggest you go check out that video that I published on September 1st of this year. So let's see what else has popped up. Okay, Doxology writes, Ernie, I have a tenant who is not sending. Oh no, I already did that. Eviction Pros writes, thanks, very helpful. Doxology, great, thank you. Oh, great, you're very welcome. Guys, this was the last of the prepared questions that I had. I hope that I got to everybody's questions on the chat. I hope that what we talked about today was helpful to you. Again, next week we will meet. It's the day right before Thanksgiving, but I will host a live next Wednesday at 4:00, and the topic, let's see, that topic will be, is there a website for me to verify that my tenant's ESA is legitimate? Kind of. I'll explain later. There's nothing official in the state of Texas, but there is a website that I'm going to refer you to that hopefully helps you with this. It's something I've talked about in the past. And if you've got questions about emotional support animals, I will have answers for you. Come back next week and see us live. We appreciate all of you who stayed all the way to the end, or those of you who are watching the replay. I hope you guys have a great week. I look forward to seeing you in the future or at some live event that we host all over the state of Texas. But until next time, landlords, let's see. Alexander says, thank you so much, Ernie. Jeff says, thank you so much, Ernie. I'm a better landlord because of this. I am so excited to hear that. Always, 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 I appreciate the great things that you guys say and the things you learn. James says, thank you. James, you are welcome. Guys, until next time, I wish you all the best. And as always,